Good afternoon. I'm Tom Ellis. I am honored to be the chapter president of the New England chapter of the Construction Management Association of America. And we're very pleased to be offering you this webinar today. And Joe Barra will be joining us shortly to make the presentation. But first of all, I'd like to thank all of our corporate sponsors that have contributed to sponsoring the CMAA chapter this year. This is one of the reasons why this seminar is free to everyone who's participating. We're trying to accommodate schedules by doing these webinars at lunch. We're also trying to make them affordable and also relevant to issues that are of importance to the construction and design industry within the New England area. So I'd like to thank you all for participating. Looks like we've got a really good attendance list today, a number of people participating. So thank you for doing so. As we move through the process today, you'll be able to enter questions you may have in the chat feature of the GoToMeeting software. If you go to the bottom, there's an arrow that says chat. You can enter a message. We would like to maybe hold questions to the end. Joe will probably take a look at them throughout the presentation, and we will answer as many questions as we have time to do so today. So without further ado, I'd like to introduce Joe Barra. Joe is a construction attorney with the law firm of Robinson and Cole. Prior to becoming an attorney, he graduated from the Virginia Military Institute and has a degree in civil engineering, and he actually worked in the profession for a number of years in New York, so he's one of us. And so as an attorney, he has a unique perspective into the construction industry. Since graduating from the Jacob Fuchsenberg, is that correct, Joe? Law Center 20 years ago, or Fuchsberg. He practiced law focused extensively on presenting public and private owners, contractors, subcontractors, architects, engineers, suppliers, and others who touch or concern the built environment in both contractual matters and disputes. So Joe is a former member of the National Board of Directors of the Construction Management Association of America, and he's a member of the CMAA chapter, MSPE, AGC, Massachusetts Building Conference, and DBIA, Design Build Institute of America. So as you can see, Joe is very connected with a lot of the professional organizations that we all touch. Joe is also a construction arbiter with the American Arbitration Institute. So he lives in Hopkinton with his family, and I would like to introduce Joe to you today, and take it away, Joe.
Thanks, Tom. Hi, folks. So today we're going to talk about the Massachusetts Prompt Pay Act. And what implications does this statute have for your management of private construction projects? So it will impact CMs who are functioning as an agent, as well as CMs that are functioning as a constructor. The statute's been around for a while, but a case just recently came down within the last few weeks that represents probably the first case here in Mass interpreting the statute very strictly. And the reason for having this program is not only to just sort of go over some of the requirements of the statute, but to explain how that case, I think, will impact the way that we manage private projects here in the Commonwealth. So let me get started with the notion of what do I need to know? We're going to start with talking about the purpose or the application of the statute, because it only applies to private projects over 3 million. We're going to talk about how the statute addresses applications for payment, their management and timing and substance. Similarly, we'll talk about how the statute addresses the administration of change orders, and what it does, what the statute does, or how it treats the notion of pay if paid or pay when paid clauses in a contract. Further, we'll talk about the statute's hammer clause, which speaks to the notion that a contractor may, by contract, be required to continue working during the pendency of a dispute, and we'll talk about how the statute applies to that. We'll also chat about the dispute, how the statute applies to a contract which has a dispute clause that requires disputes wait till the end of the project. The statute addresses that as well. And then finally, we'll talk about the impact of this recent case I was talking about, Tocci versus IRIV, will have upon your current practice. Okay, having talked about what we're going to talk about now, let's dive into it. Let's start with the purpose or the application of the statute. So, when the statute was adopted, over 10 years ago, the notion was that it was intended to improve the flow of money. That was its basic concept. It applies to private projects where the contract value, the initial contract value between the owner and the GC or the owner and the CM is $3 million or more. And it does not apply to residential units of 4 or less. So you could have a single unit house, a single family house that's $3.5 million, but it wouldn't apply even though it meets the dollar threshold. It doesn't apply to anything less than four units. So it, as I mentioned earlier, it applies to owners, prime contractors, CMs, subs, material suppliers, and anyone who is entitled to file a lien. So that excludes those in the public sector. So if you are working exclusively for the Commonwealth or for a body politic here in the Commonwealth, you could pretty much turn off your computer and go to sleep. This only applies to private stuff that meets the threshold of 3 million and so forth, provided you're entitled to file a lien, which addresses almost all construction contracts. And then lastly, which really, quite frankly, is not relevant today, the trigger in terms of its integration was for general contracts that were executed after November 8th, 2010. So that's really not an issue. Okay, so that's the purpose and the application of the statute. Let's talk about how the statute addresses applications for payment. So the statute provides outside time limits for preparing a pay app, for submitting the pay app, and for the approval of the pay app. And that's where you are in the chain of command. That's for the owner going downstream to the GC, as well as the GC going downstream to subs. The statute specifically says that the chain of command has 30 days, the general contractor and the subs have 30 days in which to submit their pay app. And then when it gets up to the next chain, and let's just use the time frame in terms of a general contractor and make it easy. A contractor submits the application for payment. It's got the owner's got 15 days to either approve or reject that pay app, which is a very short ticker. And that's one of the more important tripwires for today's lessons learned for purposes of compliance with the statute. So the owner's got 15 days to approve it. If you're a GC and you're talking about a subcontractor's pay up, you've got 15 days to approve it, but then you've got an extra 7 for purposes of the downstream chain. So the statute takes into account the fact that you've got to go through certain hoops in which to get those pay apps approved. Then once you define once the pay app is submitted, then let's go back to the owner GC model. Then the owner has 45 days following its, and we use the term approval in quotes, air quotes, for a reason, because not only is it deemed approved by application of the owner's designation of it being approved, the owner says, yeah, I approve this, and there it goes back down the stream, the chain of command, but it's also deemed approved by operation of law in terms of the statute, and we'll talk about what that means in a minute. So a failure to adhere to the time standards that I just described results in a default approval. So once again, using the owner GC as a model, if the general contractor or the CM submits its pay app to the owner within the 30-day limit, and the owner fails to respond either by approving in whole or in part or rejecting in whole or in part any part of that pay app, then after that magical 15 days, then what happens is the law says that it's deemed approved. So a failure to adhere to those time standards results in a default approval. And that, I think, is going to be the biggest challenge for us in terms of CM agents, in terms of managing projects to make sure that those pay apps are reviewed and turned around within the time frame that the statute provides. All right, so we talked about in terms of getting it done within the time frames. However, the pay app may still be rejected up until the deadline for payment. So if you look at the model of the owner and the GC, you got the GC submits its pay app, on January 1st. And then the owner's got, so he's got January 30th. They have 30 days to submit it from the time of January 1st. And then the owner's got 15 days to either approve or reject it in whole or in part. Now, as I mentioned earlier, that 15-day ticker, if it's not complied with, means that it's deemed approved. However, the statute has a parachute or a safety net here, and it says, well, we know that you got the 15-day ticker, but if the owner does not apply or comply with that 15-day ticker, the owner can still reject that pay app up until the time in which payment is due, which is within 45 days. So there's sort of a safety net of sorts for an owner to be able to still reject it before the 45-day ticker expires for purposes of payment. And that likewise falls downstream to general contractors and subs as well. Okay, so as part of that paperwork, the question then becomes, what must be included in the package that the owner sends to the general contractor for either rejecting all or part of that pay app? Well, if the owner decides that part of that application for payment is not authorized, then it needs to be a response by the owner in writing, and that writing needs to have a factual description as to why that payment is arguably, or that application for payment or part of it is not appropriate, as well as a reference to the party's contract or contractual reasons as to why payment or a portion of that payment is not due. And then at the in addition to having meeting those two criteria, the rejection needs to have a good faith certification stating that the person who's rejecting all or part of that pay app needs to certify that the rejection is in good faith. Now, the statute doesn't provide a model of what kind of language that we would use for that purpose. That would be something you'd want to talk with your lawyer about to make sure that it complies with the statute. There's really not a whole lot of magic to that. I believe that the statute left that language out purposely, just so that there could be some flexibility in terms of what that certification, good faith certification, looks like. But nevertheless, it needs to have a good faith certification as well. So let's talk now about change orders, because it's a similar model for change orders than it is for pay apps. So the statute speaks to requirements for the process, but it doesn't speak to entitlement. Those things are under the contract. So if the rejection for a pay app or a change order that's not part of the contract, or you're asking for something that the contract does not provide, then the contract controls. So the statute does not say or speak to a general contractor or a subcontractor's entitlement. It's purely process. The statute establishes time limits for approval or rejecting a proposed change order that comes up through the chain of command. And those change orders are similar to what we talked about in the context of a pay app. The deadline for an owner to approve or reject a proposed change order from a general contractor is 30 days from when it's submitted. And likewise, if the proposed change order is found its basis from the subcontractor, there's an additional 7 days to accommodate the fact that it's lower down on the food chain. And those timeframes are triggered from the submission of the PCO, or if the contractor or the subcontractor commences work on a request for on a change order from an owner, whichever is later. So the point here being that while the trigger date could be flexible as to whether it's the submission of the PCO or the contractor's beginning work pursuant to a PCO, there's nevertheless 30 days from when that work or that approval or that submittal is made in which to either approve or reject it. So a failure to adhere, much like the pay app situation, a failure to adhere to these timeframes results in a default approval. So the statute basically says that if a general contractor does not or submits a PCO and the owner does not approve or reject it within 30 days from the time frames that we just talked about, then by operation of law, the statute says you've now bought this change order. It's part of the contract. It's deemed to be approved. Once again, there's another safety net, and that is that the PCO may still be rejected up until the time or the deadline for payment. So this the change order process sort of overlaps with the application for payment process. So when you flip now from a PCO to an application for payment in terms of the time standards, the owner has at least this safety net that says, well, I know I didn't reject it within the 30 days, but the time frame hasn't yet expired for me to pay you for that work, and I still have the ability to reject it within that time frame. So it does have some safeguards here. But once those time frames are expired, then it's deemed approved, and there's no going backwards. Once again, much like the pay app process, the change order process requires both a factual and a contractual reason for a rejection, as well as a good faith certification. And once again, there's no specific magical language for the certification, but it has to contain one, and it has to contain both a reference to the contract as to why that all or part of that proposed change order is not being integrated into the contract. So the statute also addresses pay if paid or pay when paid clauses. And for those of you who are unfamiliar with this concept, the idea of a pay if paid is where, like, for example, between a GC and a subcontractor, if the subcontract says that the GC has no obligation or as a condition precedent to the sub to pay its invoices until it gets paid by the owner. And so that's the pay if paid concept. And then the pay when paid is similar, but there's a nuance, and that is I will pay you when I get paid from the owner. Now, on the pay if paid clause, the Massachusetts common law requires some magical language that we won't go into here this afternoon to make it a pay if paid, which gives the contractor the ability to say, nope, the obligation to pay you, Mr. Sub, has not arisen. Once I get a payment from the owner, then I have the obligation to pay you. Conversely, if you don't have the magical language, we talk in legal parlance as a condition precedent, we have a pay when paid. And courts have interpreted those kinds of clauses to say, hey, if you don't have the magical language, then the general contractor's obligation to pay the subcontractor exists probably within a reasonable period of time, most likely 30 days. So that's how that works with respect to that distinction. Now the question is, what does the Massachusetts Prompt Pay Statute say about those two concepts? Well, it basically eliminates the enforceability of pay if paid provisions between between general contractors and subs, except in two very limited circumstances. Those circumstances, the first one is where the party who's requesting payment, they're requesting for defective work for which the upstream entity does not pay. The idea here being that if a subcontractor is saying to a general, hey, pay me for this defective work that I did, if the general contractor says no, because the work is defective, he has the right to rely on the pay if paid language in the contract, if there is one, that says, no, the owner didn't pay me for your defective work, and I don't have the legal obligation to pay you either. So in that one of the two circumstances, a general contractor can enforce its pay if paid clause with the sub. Secondly, pay if paid clauses will be enforced if the upstream entity is insolvent, provided further that the party requesting payment has previously filed a notice of contract under the lien law. So the idea here is, for the second contingency, is that a general contractor can tell a subcontractor, I'm not going to pay you, even though you did work, and there's no debate about the work, if the owner went insolvent because I haven't gotten paid as the general contractor and the owner hasn't paid me. They're now in bankruptcy. And so I'm going to trigger the pay if paid provision. However, there's this sort of this additional requirement that requires the party who's requesting payment to have previously filed a notice of contract. So that in order for the sub to get paid, they would have to file the notice of contract timely under the lien law. So the statute also addresses what we call in legal parlance the hammer clause, and that clause basically deals with a provision that requires a party to continue working when a pay app that's been approved is more than 30 days late, except in two very limited circumstances. So if you have a contract provision that requires your downstream subcontractors to continue work, even though they haven't gotten paid, that's unenforceable. That the statute makes it unenforceable. But there are two exceptions. And of course, there's exceptions because we're lawyers and we have to deal with exceptions. That's how come we get paid. So one of the exceptions to the hammer clause is if the party seeking payment is in default. And that's easy. If the subcontractor is in default of its pay obligations, then the general contractor can enforce its hammer clause downstream. Secondly, if the party, in this instance maybe a sub, is requesting payment for defective work, then the general contractor can enforce its hammer clause by saying, no, I'm not paying you, and under the provision of the general contract that we just described. Okay, so that deals with hammer clause. So now let's talk about the dispute clause and what does the prompt pay statute say about that. So with respect to provisions in a subcontract that speak to waiting until the end of the project in order to trigger it, the statute disavows that and renders it unenforceable. So if you're a subcontract with a GC or a CM has a provision that says you can't sue me or trigger the dispute clause until the end of the project, the statute says, nope, that clause is now deemed unenforceable. So having gone through, at least in a brief way, what the statute speaks to and the requirements for process, let's talk about what happened recently with this case, Tocci versus IRIV. And how will that recent decision impact our current practice as to how we manage projects? So let's talk about the case first, so you have a context and understanding. The facts in Tocci are as follows. The contractor was hired to construct office and lab space here in Boston at the Seaport. The contract price was more than $3 million, so the statute applies, right? It's more than $3 million trigger, and it's a private project. And the contract provided between the owner and the GC for shorter deadlines for making objections. The statute, remember, says that it provides an outset. It can't be more than 15 days, and the contract here said that any objections from the owner for making an objection to an application for payment must be done in 14 days, so that fell with under the outside deadline of the statute. So that was good for purposes of compliance. And then the contract further provided a shorter deadline for payment. Remember, the statute says it can be no more than 45 days. The contract said that payment, if approved, deemed approved, will be made within 30 days. So the contract complied with the statute's outer limits on that as well. So here in the Tocci case, the owner's project manager refused to pay all or part of 7 of Tocci's periodic pay recs. So there was a situation where Tocci would invoice and the owner's PM refused to pay all or part of them. And that went on for 7 recs over the course of several months. The court held the PM failed to timely respond to most of Tocci's invoices, at least properly. So there was some timing issues where they didn't, the PM acting on behalf of the owner did not comply with the 15-day ticker that we talked about earlier in terms of the statute's requirements. and didn't, and they fell outside the 45-day payment window as well. Remember, we said that there's a second parachute that gives an additional time in which to reject them, and so for most of those invoices, the owner didn't comply with any of those timeframes. None of the project manager's responses provided an explanation of either the factual or the contractual basis for the rejection. Obviously very important. We talked before about that the rejection not only needs to be timely, but has to comply with those two requirements and for purposes of advising the general contractor why they're not being paid. None of the PM's responses included the certification that was required for good faith. It was a situation where there was no certification at all. So you had a situation here where that wasn't timely, didn't comply with the statute's requirements for an explanation, contractually or factually, and it didn't have the good faith certification. So what happened? You had a situation, the court said that the PM had submitted some emails responding to the pay apps, but even the emails didn't strictly comply with the statute's requirements. The court found that the statutory compliance was mandatory. And what's important here is that it reflects a public policy of prompt payment or prompt and complete notice of objection. So the court was enforcing the statute strictly, which is really important because that was sort of the thing that the construction bar was waiting for was, well, would a court enforce this statute, by holding people to their timeframes, by holding them to the requirement of whether it has to have a contractual notice, whether it has to have a factual notice, and what about the certification? Are courts going to enforce these things to the letter? And the court said yes, that strict compliance was mandatory because the court looked to the statutory purpose, saying, look, the statute was intended to address prompt pay issues, and if the contractor is not going to be paid, then they should know what the problems are as to why. So what else did the court hold? The court found that the contractor's requisitions were thus deemed approved by operation of law, even though the owner or its project manager had not complied. And then the court entered separate and final judgment and directed the owner to pay the general contractor $4.6 million. What's kind of interesting about the separate and final judgment for any of you legal scholars out there is that generally in a case, a court is reluctant to enter final judgment on a matter until all the case is done. If there are still lingering issues, you might be able to resolve some of the issues in a case early on, either by summary judgment or whatever. But final judgment is typically, the end of the road, if you will, after a trial or after some kind of a process where judgment is requested. Here, in this situation, there were still issues to be resolved in the dispute, but nevertheless, the court agreed with Tocci's counsel by asking the court to say, well, you know what, these other issues can wait. Let's issue final judgment. And I want, this thing is, I'm owed $4.6 million. I've been waiting a long time. I need that money now. And the court agreed, saying, you're right, you're entitled to that. The statute was entitled to, it was called prompt payment. So we're going to make the owner promptly pay you now. So that was sort of an added bonus for the contractor in terms of getting that judgment accelerated. This is an important issue. Court added in its decision that, and it quote, whatever objections a project owner may have under the contract to the general contractor's requisitions were deemed waived. What that means, it's pretty broad. And what that means is that even if an owner has a substantive reason for not paying, and this could be for defective work, right? I'm not paying you because the work you did was bad. It didn't comply with the contract's requirements. If the owner doesn't comply with the statute's requirements for notice, for timeliness, for a good faith certification, so if it doesn't comply with the prompt pay statute's process, the court here found that whatever objections the owner may have to that rec, whether it's defective work or otherwise, those are deemed waived. So arguably, you could interpret this language in the court's decision to mean that even if the work that Tocci did was deemed defective, the owner would still have an obligation to pay it because the project manager did not timely and properly comply with the statute's requirements. That's huge. That's huge in terms of now requiring an owner to pay for defective work just because they didn't comply with the statute's process. But that's what the language said. So stay tuned to see whether that case goes up when it goes up on appeal, whether that's overturned. So let's talk about what are the implications of the decision. It's clear that CMs, both agents and constructors, need to pay attention to the statute's very detailed requirements, as do owners by virtue of the owner's OPM. Secondly, we know that from the decision that strict adherence to the statute will be required when responding to a pay app. We know that strict adherence will also be required when responding to a proposed change order. We know from the Tocci decision that emails in response to a pay app which vaguely object to the requisition or just comment upon certain deficiencies in the invoice are not enough to trigger or to satisfy the statute's requirements. That underlying entitlement to payment is not part of the statutory analysis. Once again, nothing about the court's decision addressed whether Tocci was really entitled or deserved payment, whether the work was defective or not. That analysis was absent from the court's analysis, the court's decision. It was just whether the project manager on the owner's behalf had complied with process. So underlying entitlement is not part of the statutory analysis. A contractor need not insist that an upstream payer provide the required explanation in order to take advantage of the statute's protections. And what this means is that the Tocci did not have to insist on the owner. It says, look, hey, owner, you have an obligation under the Prompt Pay Statute in order to respond to my pay app or pay me within certain time periods. In other words, the contractor need not insist that the upstream, in this instance, the owner, provide the requisition, the explanation in order for Tocci to take advantage of it. You don't have to remind them of that. I mean, I think it's a good practice, but nevertheless, it's not required. A payer who fails to comply with the statute waives its right to assert contract-based objections. So here, once again, if an owner fails to comply with the statute, it has now waived its right to reject a pay app and quite frankly also a PCO based upon objections that they might derive from the contract. So you can't rely on the contract as a reason if you're late or if you didn't provide the notice that the statute requires. A failure to comply with the statute may waive objections to a contractor's subs defective work. So we talked about that in terms of the idea that there's no the entitlement piece is absent from the analysis. It's purely a process analysis. I think finally, a PM's failure to properly manage the pay rec or the change order process on an owner's behalf could be found liable to the owner for payments not ordinarily due or extra work not authorized. So I can certainly see a situation where a PM, whether it's a CM agent or an OPM acting on the owner's behalf, who fails to manage this process correctly, whether it be on the pay app process or the change order process, and then for the pay app to be deemed approved as a matter of law, or for the change order to be deemed approved as a matter of law because the owner's OPM or PM didn't fulfill its obligations under the statute. I could see how if that payment or that change order was not ordinarily due, if the pay app was not ordinarily due, or if the change order was not bona fide, I could see how an owner could come down and find the project manager liable to the owner for the costs that now the owner has to pay, subject to what we call betterment issues. But nevertheless, I could certainly see how this could be a fertile ground for OPMs and project managers for failure to comply with the statute to their client. So we've got some time here for purposes of a Q&A. So let me open that chat room to see if I could see if any questions. So I've got a question here. It says, Joe, can you talk about why the statute is limited to the private sector work only and is not applicable to public sector work? Well, that was a decision that was made during the statutory adoption process. You could argue that Massachusetts statutory scheme has a prompt pay provision where, I think it's 149 has a sub provision that speaks to a general contractor's obligation to promptly pay its subs once it gets payment from the owner. So you could take a position that you don't need one. Nevertheless, I wasn't part of that drafting process. The idea was to address it in the private sector only for projects for which a lien was permissible. So let's see if we have any other questions here. Okay. So Tom or Austin, can you tell whether there are any other questions in the chat room? Not sure if you can hear me, guys.
Yes, at this point, I do not see any. I know Austin had sent out a message to everyone in the audience where to find the chat feature on the GoToWebinar box. So if there are any questions, I know Joe has got some time to do that. So
we do have some questions, and I will get those over to you.
Okay.
So Joe, while we're waiting, could you maybe, as Paul Harvey used to say, and I guess I'm showing my age, is what's the rest of the story? How did the project end up relative to completing the project and finishing the job despite this dispute that occurred? Just an overview.
Tom, honestly, I don't know. I'm going from the court's decision with regard to the pay up process. I don't know the answer to that.
Okay. So it looks like there's a question here. Does it help to notarize any of the documents throughout the process?
The statute doesn't require a notary. I don't think that necessarily it would add anything because the notary really is basically saying, hey, look, the person who signed this document is the person who they say they are. Really, the most important piece of the good faith certification is the notion that the person who is either rejecting all or part of the pay app or the proposed change order, has done a fairly thorough analysis of the project's facts and the contract and has made the determination that the contractor or the invoice is not proper and the payment is not due. So it's less about the formality of what the certification says or the window dressing and more in line with the notion that you have a reference to that a good faith effort was made and that the rejection is made in good faith and a reference to the particular section of the contract for which the rejection is being based on, as well as the facts.
Right. So one follow-up question I would have on the issue, a lot of contracts have the designer as responsible for certifying the application for payment on behalf of the owner. In some instances, the owner wants the OPM to either concur with or sign or whatever that is being done. How is this relevant? I guess the contractual provisions would be important as to who is actually certifying the payment application or approving a PCO on behalf of the owner contractually.
That's right. So the design professional, to the extent that they are tasked with construction phase responsibilities to review pay apps and propose change orders, now has the burden or responsibility if part of that pay app or PCO is going to be rejected, to comply with the time standards there. So once again, you have a situation where, depending on who's running the ship, if you will, for purposes of managing that process.
Right.
Okay, hold on a second. Got it. I don't want to skip anything here. Do you need to file a lien in the event of non-payment? No, the statute does not require that parties who want to take advantage of the statute have filed a lien. Certainly, if you're an unpaid contractor, subcontractor, or material supplier, we would encourage you to secure those rights, understanding that a lien is merely a security instrument, which basically says that you still have to prove the debt. You still have to demonstrate that you're owed the money, that you did the work or furnished the material or the goods or whatever it is that you're intending to get paid for. But that ultimately, if you demonstrate your entitlement and you don't get paid, and that's when the lien kicks in to say, yes, here's security, financial security for that debt, but it's not a requirement for purposes of taking advantage of the prompt pay statute. Let's see. Okay, if a change order can only be approved or denied within 30 days, how does the negotiation phase work? Well, you would assume that it may be like a pencil wreck, or that there would be a discussion ahead of time. But nevertheless, if there's not, then the PCO, whose delivery operates as the trigger date for purposes of the 30-day clock, for purposes of negotiation. Now, you can't remember, the statute says that it's the outside. You can't have it more than 30 days. So you can obviously, if you accelerate the negotiation process, you can do it within the 30-day process. But once you step outside that 30 days on the 31st day, now you're in the red zone for purposes of it being deemed approved, subject to that safety net we talked about as to when payment for work is due. So this clearly represents, in my view, as you probably noticed, a paradigm shift in terms of how we currently do things, and the expedited way in which these kinds of negotiations have to take place. Okay, let's see. How does the statute apply to retainage? Great question. There's another statute which was recently passed called the Retainage Act, and that sort of deals with final payment and project closeout and how retainage gets paid. The prompt pay statute treats progress payments in the way that we described. When you get to payment for retainage, the retainage statute sort of takes control, if you will. So stay tuned. Maybe we'll do another program on the Retainage Act. Does the applicability of the act spring from the contractor's billing within 30 days of providing work? If so, how does this affect milestone billings, which might not be 30 days? Let's see if we can figure that out. Does the applicability of the act spring from the contractor's billing within 30 days of providing work? I'm not, forgive me, Sean, I'm not really sure I follow that. Let me see if I can answer that question the best way I can here. So if the statute says that you've got 30 days from when you finish the work for the given month to invoice. So using the calendar as a model, you do all your work in January 1st through the 31st. You now have 30 days. So that would be February 28th, aside from leap year, you have to like March 2nd to invoice. That's how the 30 days would be triggered. If so, how does this affect milestone billings, which might not be? Yes. Okay. So one of the questions I've always had is, what about milestone billings? In terms of you're not dealing with pay apps that come out on a calendar basis, but in fact you achieve certain milestones of the project, plumbing's complete or roofing's complete or whatever, or processes, if it's a facility that's manufacturing or otherwise a treatment process. What about that? Well, unfortunately, the statute doesn't address that. So what you have to do is you still have to do payments now in accordance with the calendar. Does that mean that you can't do milestones? No, not necessarily, but they have to sort of fit within the statute's 30-day ticker. So how you do that represents, I think, a very difficult question to manage that. But it's a great question, and I haven't seen a contract in a while that actually attempts to do that in terms of use milestones and combine them with a calendar. So that's going to be a problem. That's going to be an issue. How does this relate to T&M work? Well, broad question. I don't think it changes anything. If you have a contract that trips the statute's wire, meaning that the estimated project cost is going to be over $3 million, and it's a private project and blah, 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 so the statute applies, you still have the obligation to do the invoicing 30 days after you finish the prior month. And then change order work, obviously then becomes a question of what's in scope and what's out of scope. So if a contractor believes that work that it's performing is outside the scope of time and materials, then it has to comply with the statute's requirements for purposes of submitting that PCO within the 30-day ticker. What technologies are out there that can help the GC owner or the subs can use to automate the prompt pay draw process? Great question. Don't know. You'll have to talk to your IT folks. I imagine that some of the project-specific websites, have those kinds of built-in calendars, but you'd have to obviously make sure. I mean, it's kind of funky when you talk about the 30 days because we don't have many months that deal with only a 30-day ticker. So then you've got this, this query, like, for example, if, you finish work after January, the payment's not due. I'm sorry, the invoice isn't due until March 2. So you completely missed the month of February for that purpose. But Rory, I wish I could help you. I don't know as to whether there's software out there that can help you automate this. I imagine there might be that can be adaptable, but I can't answer that. Interest provisions for non-payment. The statute doesn't apply, doesn't deal with interest. It's whatever the contract provides. Once again, here's where you've got the distinction between what the statute was intended to accomplish and then and leaving the contract on its own to deal with these kinds of issues. So here, if a contract said that the amounts not paid when due shall accrue interest in the amount of X percentage per month or per day or per year or whatever, those provisions control. Absent a contract provision that has an interest section in it, then you default to statutory interest here in Massachusetts. If an owner rejects the payment or PCO at day 44, does the time clicker start over? Okay, so if the 30 days is not met, the statute allows the owner or the general contractor downstream to reject that pay app or that PCO before payment becomes due. So when we talk about does the time clicker start over, not sure, Tom, I fully get what that means. What happens is that the next requisition, doesn't start from that period. It goes from the calendar month. So if you don't pay the let's just say, take January as an example. So you finish the month of January, and then the rejection doesn't come by March 2nd, but comes March 22nd. And payment hasn't been due, so that would be arguably timely based upon that safety net issue. But nevertheless, the pay app for the month of February would not start at the March timeframe. It would be that now payment for February is due 30 days, or not payment, but requisition for February is due 30 days from February 28th. So you finish the month of February now. Now you get 30 days. You get March 30th. That's when the payment application would become due. Hopefully that answered your question. It does get funky in terms of the calendar, and it's very confusing that way in terms of trying to figure out the days. You really need to start counting off days when you have a contract. You have to look at the calendar very closely. What if the magnitude of the change requires more time to vet? Is there a mechanism to respond indicating that more time is needed? Carol, that's a great question. The statute gives you 30 days. And what's also interesting is the statute does not provide you the ability to modify that 30 days. My feeling is that if two reasonable parties are still in the process of negotiating a change order that requires more time, that you can probably try and reach an agreement to extend that. Although, quite frankly, I know a lot of construction lawyers would disagree with that. But sometimes, like you said, if it's a big change, you may not be able to do it within a 30-day time frame. Maybe the solution here would be to do it in pieces, so that you're addressing certain parts of the change order within the time frame, and you're leaving those issues that are still debatable outside the framework. But nevertheless, the statute says what it says, and so it's difficult for me to sit here and tell you to not comply with the statute. But that may be one way to try and deal with it. All great questions, by the way. Can you give us a crystal ball take on how the appeals court will rule on appeal? I think the decision is going to be upheld. I think that the decision is fairly clear, that the PM did not do what the statute required. This was not a situation where the owner, missed the deadline by a few days and stubbed its toe. This is a situation where the lower court found in a very express ruling that the PM did not comply with what the statute required in several ways. And I think an appeals court will have a very difficult time navigating a way out of that. So that's my crystal ball. How does the timing for payment begin when most contracts do not allow you to invoice for work that is not approved? Another great question, Scott. We're going to have to change the way we do business based upon this statute. So here, when most contracts don't allow you to invoice for work that's not approved, the idea is that you will, if you've done work and you believe you're entitled to it, even though the contract says you're not allowed to invoice for it, the statute is going to require you to do so within that 30-day ticker, and let the owner reject it based upon the fact that it arguably wasn't approved work to begin with, and that's going to trigger a fist fight. But it's very difficult to overlay the statutory timeline with the process that you've described, where owner says you're not permitted to invoice unless I approve the work first. But if you've done the work and you believe it's a change order, then obviously you've got the statute's provision, the 30-day ticker for PCO. If the CM has a contract with the owner and the owner also has an OPM, who is ultimately responsible for adhering to the statute on the owner side? And that's the owner. The owner is responsible for making payment. And then assuming that the model, Tom, that you're describing is where the OPM is merely acting as the owner's agent, and that the OPM is not required to make payment themselves. In that instance, the owner's got the obligation and pay risk, and so they're responsible for complying with the statute. If in fact the OPM, who's responsible for managing the process, fails to comply with the statute, and the pay app is deemed, quote, air quotes, approved by operation of law, and the owner was basically saying, no, that was wrong, that we should never have, we should never be paying for this work that was not done, it was defective or whatever, then the OPM has got some answering to do in terms of its exposure to the owner. And so that's why I see this as a huge watershed moment for those who are functioning as an OPM in terms of making sure that you're looking at the calendar very closely so that you have your ducks in order when those pay apps come in and when those PCOs come in. Project communication is going to be very key moving forward in terms of making sure that the statute doesn't trip anybody up as an Achilles heel. Do you have to use AIA change order forms, or can company created change order form to meet the change order submission requirement? Certainly, those you can use, I mean, the world of construction law is you can use any contract form you want. You don't have to use an AIA change order form or not. But nevertheless, you may have to change or modify the change order form within the AIA family. Obviously, we can help you. I would suggest that, Megan, that you go talk to your favorite construction lawyer about making tweaks to those standard forms to address compliance with the Prompt Pay Act here in Massachusetts. What are the damages that result from not complying with the statute? Well, the statute doesn't provide any particular damages other than to say that the change order is deemed approved and that the pay apps are deemed approved. So the amount of, so if you have, like in this instance, you have a situation where the owner did not comply with the statute's pay application response dates, then the owner was responsible for paying those invoices as a matter of law, whether it thinks it's entitled to, whether the owner doesn't think the contractor is entitled to or not. So I guess that could operate as a damage, but nevertheless, they're obligated to pay money that they arguably would not want to pay. Plus, we talked a little bit earlier about interest. To the extent the contract provides for interest, then that would apply, assuming it's not usury. And if there's no interest provision in the contract, then statutory interest would apply. But once again, the statute, the statute does not say that there are certain kinds of damages like treble damages or double damages for a failure to pay. Can terms and conditions of a prime contract effectively override components of the law, i.e. 60-day payments or extend durations? No, the statute's very clear that parties cannot change or modify the contract's outside dates for compliance. So if you've got a 60-day payment provision, you're over the 45-day limit. So that's going to have to be adjusted. What will happen is the statute would control in that situation, and a payment not within 45 days would be in violation of the statute, even though the contract says 60. So that's why, Rennie, I would suggest that you, to the extent that you have standard contract forms, you probably want to run those by your favorite construction lawyer to make sure that the forms themselves comply with the statute. Otherwise, you may think you have rights that you're not entitled to because the statute trumps the contract. Does the statute require that PCOs be submitted within 30 days of work performed? Well, remember, let's see if I can go back here. 1 minute. Maybe I can't. Okay, I can't go backwards. You may recall that the slide that dealt with this had two contingencies. One was that the PCO had to be responded to within 30 days of submission or within 30 days of when the work was performed. So the idea being that the statute accounts for the fact that you may have situations where a contractor is forced to perform change order work without having the documents in place and so forth. So in that instance, the statute says, all right, well, if you don't have, a PCO that's been submitted but the contractor has now been asked to do an extra foundation or whatever, and they're starting that work, then you have 30 days from when the contractor begins that change order work. Obviously, you still have notice requirements as a contractor to provide to the owner that you consider the work to be extra. So you still need to fulfill those obligations. But here the statute was flexible enough to say, no, it could be 30 days from either the submission of the PCO or if work has already started from 30 days from when the work starts. I realize we're at 1 o'clock. I'll take one more here. Nope, looks like we're getting cut off. All right, well, thanks those for attending. I think, Tom, you have, you wanted to say goodbye?
Sure. Just like to thank you, Joe. One of our favorite construction lawyers, as you referred to. Thank you. We have a number of them, but some of them are, actively involved in the CMAA. But I'd like to thank you and our sponsors, and I'd like to note that Robinson & Cole is one of our corporate sponsors for the CMA chapter, and thank you. WSP, PMA Consultants, CBRE Heary, Whiting Turner, VHB, Kevel Enterprises, Stantec, Caminiti Construction Advisory Services, Gilbane, STV, HNTB, GPI, and City Point Partners. Those firms have all supported our chapter in allowing these webinars to occur at no cost to the participants. We've had really good attendance today. I'd also like to notify everyone we've got a joint webinar with the Society SAME on Tuesday, March 16th, which is a noon webinar on a look at workforce hiring practices and management challenges. So we encourage you to continue your venture into continuing education during this pandemic and appreciate your participation. And thank you for joining us. Thank you.
Bye, folks.